Director of the Center on the Legal Profession, and it's my great pleasure to welcome you to today's panel discussion. In Unspeakable Acts, Ordinary People, John Conroy noted that throughout the world, torturers are rarely punished, and when they are, the punishment rarely corresponds to the severity of the crime. One reason for this, according to Conroy, is that those involved in torture generally are not sadists who are easy to condemn. Rather, they view themselves as servants of the state engaged in a just war. That's certainly true of the government officials who authorized enhanced interrogation practices that the international community defines as torture, and those who have declined to hold them accountable. Public opinion polls in this country find that Americans are equally divided over whether the lawyers responsible for writing the so-called torture memos should be referred to disciplinary authorities for possible sanctions. According to the Assistant Attorney General in charge, David Margolis, the lawyer's conduct reflected poor judgment and constituted an unfortunate chapter in the history of the Office of Legal Counsel, but did not rise to the level of intentional misconduct. That conclusion met with severe criticism throughout many circles. The New York Times editorial characterized poor judgment as an absurdly dismissive way to characterize facilitation of torture. Some have suggested that the government's unwillingness to evaluate the conduct of its officials reflects broader institutional and political failures. That's the subject of today's panel. It's one I think we need to address in law schools. It comes up in my classes on legal ethics and leadership. And today we're blessed with an abundance of expertise to talk about the topic. I'll just conclude by introducing the person who made this event possible with my thanks to him, and he will introduce the speakers and provide appropriate thanks to everyone else. Bill Roller is president of the Berkeley Group Education Foundation, a nonprofit corporation that organizes presentations and symposia on issues vital to the public interest. He's the ethics chair of the International Association for Group Psychotherapy and Group Processes. With his wife, he's the author of some 40 books, articles, and book chapters, as well as videos in the fields of group therapy and group process. Thank you so much, Bill, for making this event possible.
Yeah. Thank you, Deborah. This panel is being videotaped today. The audience will not be on camera. Proceedings will be placed on YouTube for general dissemination. I want to thank Professor Rhode, my co-organizer of this event. She's brought to fruition Professor Cole's wish that Stanford Law and Berkeley Law renew their collegial contact around issues of great import. We're also grateful to Stanford Center on the Legal Profession, Jody Carrion, Jackie Del Barrio, and Suzanne Peterson for their help in making this event possible. It's my hope that what we do here today will stimulate and promote the development of curricula in law schools nationwide in order to address the many constitutional law issues that arise from the August 1st, 2002 memos of the Office of Legal Counsel, which rationalized and condoned torture. Those issues pertain to the separation of powers between the executive and legislative branches of our government, and the interrogation of those detained for reasons of national security. By these means, we hope to demonstrate to a new generation of law students a commitment to the fundamental values that underlie the United States Constitution and the U.S. legal system. This is the 5th presentation on torture that I participated in nationally and internationally. Our nonprofit organization shall conduct a symposium on torture and law for the International Congress in Cartagena, Colombia in 2012. Although our presentation today will focus on United States law, the subject of torture is of enormous interest to my international colleagues who historically have looked to the United States for leadership in the realm of human rights and social justice. The psychological professions have done a good amount of soul searching and reflection on their role in the planning and execution of torture. I'm pleased that presentations of this kind have contributed in a modest way to the creation of ethical guidelines to counsel and support those mental health clinicians who may be pressured to conform to behavior that transgresses ethical limits. I hope today that we shall contribute in a small way to awakening a similar kind of soul searching within the legal profession, and perhaps inspire the development of appropriate guidelines for legal counsel, as the psychological professions have done, in order to help resist help lawyers resist the pressure to conform to behavior that is antithetical to the core values of the profession. Finally, I want to briefly highlight 3 points. First, psychological research shows that most people can be induced to torture others, given a group structure where authority permits and encourages scapegoating and dehumanization of one group by another. The research findings of Stanley Milgram and the findings of our own distinguished panel member, Bill Zimbardo, show how susceptible ordinary human beings are to commit torture. Placed within a certain context, most of us would become torturers, given the following conditions: that we agree to obey authority and our peers are complying with orders to abuse. Whatever our self-concept, we do not need encouragement to act in ways that we are in fact highly susceptible to follow, even against our own conscience. Second, the effects of torture can last for generations, not only for those who are tortured, but also for those who commit or condone and make torture possible. This outcome is not intuitively obvious. Our colleagues in the United States and internationally have documented the fact of transgenerational transmission of trauma. This means that parents who have committed torture or advocated torture transmit the negative effects of their own traumatic stress to their children. The children of torturers and the children of those who condone and facilitate torture are equally scarred by the events they took no part in. This is an enduring legacy of torture, extending for generations into the future. Third, the United Nations Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment is the law of the land. This is and should be a covenant for all time and among all people. It is and should be jealously defended by lawyers and legal counsels everywhere. Justice Jackson of the United States delivered the opening address of the Nuremberg trials in 1945, when Nazi leaders were brought to justice for their crimes, including torture. In his statement, Jackson concluded the following: "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well." I submit that torture is that poisoned chalice. It will require much detachment and intellectual integrity to do justice to the many issues